Machiko, would you do a roll call?
Will do. For Damien. Dr. Buhari,
Present.
Dr. Jensen, Dr. Luzak,
Present.
Andrew Marino,
Present.
Dr. Patel,
Here.
Denise Pines,
Here.
5. There's 5. Is that a quorum? Okay, quorum established.
Okay, we'll go ahead to agenda up. Michael?
This is Michael Connotes, legal counsel. We have two members appearing remotely that are not on as of yet. So I think, Mr. President, we can continue. We'll just need to acknowledge them when they appear. Yes.
Okay, we'll do that. So we'll move on to agenda item number 12, which is enforcement and probation unit updates. Executive Director Erica Calderon.
Thanks, Dr. Bahari. This is a report on the board's enforcement and probation program updates for the first and second quarters of fiscal year 2023-2024. Please refer to attachments 12A, which encompasses the enforcement and probation program statistics, and attachment 12B, which is a list of our probationers' violations and the top 3 most common violation types. The enforcement unit continues to do extremely well. Enforcement staff continues to receive training in all areas of the enforcement process, and the unit is getting stronger. They are conducting desk investigations, referring cases to the field, executing their own administrative citations, offering their own pre-accusation public letters of reprimand, referring their own cases to the Office of Attorney Generals, and subsequently filing their own disciplinary orders. Enforcement did recently lose Ms. Mia Quinn to a promotional opportunity in our licensing unit. However, as mentioned before, they have gained Ms. Andrea Harmon, who previously held the position of the board's receptionist. Ms. Harmon will not only be assisting with complaint intake, but as a staff services analyst, she will be carrying her own caseload, which will help reduce caseloads in general and processing times. She will also be receiving a lot of her training by myself. Enforcement staff is also preparing for the implementation of the new requirements that SB 815 will bring to the staff. The unit is working on creating new template letters and updating Breeze with new activity codes in preparation. The goal is to be ready for full implementation of all requirements when the board receives its funding. Enforcement staff continues to work with the Department of Consumer Affairs Breeze team daily to improve database and efficiencies. And most recently, Ralph and I have submitted some requests for the probation unit. We continue to work with the Division of Investigations non-sworn unit on most of our cases that are being referred for further investigation. You will see in our statistics that we are referring a lot more cases to the field. To help with case aging, enforcement staff continues to meet with me on a monthly basis for case reviews. In addition, they continue to receive their individualized monthly pending reports, which highlight high priority and statute of limitations cases. I'd like to kind of take a little bit of time to go off with what I have here to say that that report also encompasses the class and complexity. So if there are any high priority cases based on that class and complexity, death-related cases, sexual misconduct, impairment, that report also allows me to highlight those things for them so that they can move along on reviewing those cases a lot faster, leading to faster submissions to HQIU staff. In terms of communication with our stakeholders, we continue to meet with HQIU. the Attorney General's office, and our legal counsel on a continuous basis. The board is also working very diligently on revising our disciplinary guidelines. As mentioned before, we hope to have a draft for your review at our upcoming board meeting in May. In terms of program statistics, if we can refer to those attachments, please. The first attachment, which is 12A, covers our enforcement program Q1 and Q2 statistics for fiscal year 2023-2024. Performance measure PM1 covers the amount of consumer complaints and arrest and convictions received in comparison to last year at this given time. The board is seeing a significant increase of about 41% in consumer complaints and a decrease of about 26% in the arrest and conviction cases, bringing the total number of complaints received to an increase of 37 in comparison to last fiscal year. The board believes that some of the changes that are accounting for this increase could be coming from the revision of the Medical Board of California's website, where they are now redirecting our consumer complaints to us. So we are seeing that slight decrease because we're not having to wait for those complaints to be redirected through a slower process. Performance measure 2 is the average number of days it takes for our analysts to initiate our enforcement complaints and acknowledge receipt. In this area, last year, we were suffering tremendously. The target for this performance measure is 10 days, and we continue to be well under the target at a 4-day average for the past 2 quarters. Performance measure 3 is the average number of days it takes to complete investigations and enforcement actions for cases not referred to the Attorney General's. Cases aging here fluctuates greatly because it takes an average of all of our cases, and 1 or 2 very complicated cases can skew these numbers drastically. These numbers do include the timeline for HQIU investigative staff. The target for PM3 is 360 days, and as you can see, we're roughly at 210. Performance measure 4 is the average number of days it takes to complete investigations and the enforcement actions on those cases transmitted to the Attorney General's office. Case aging in this category has a slight decrease of about 7% in comparison to last year. So far this fiscal year, the board is well under its performance measure targets for 3 of its categories, which is amazing. The PM4 is the measure that unfortunately the board has less control over, as this measure, as mentioned before, takes into consideration the timeline from the Attorney General's office, the legal representatives for our respondents, and the Office of Administrative Hearings. The board currently has 436 pending enforcement cases in our office. 63 of those are pending at HQIU, and 24 are at the Attorney General's office. Analysts are averaging a caseload of about 145 cases each. And as you know, we have 3 enforcement analysts, which is not excessively high, but not ideal. However, as previously stated, with Ms. Harmon moving into the enforcement unit and carrying her own caseload, that average will drop to roughly about 109 cases each, which is more manageable. As we continue to address older cases, we are hoping to bring that average down to about 80, which will be ideal for an enforcement analyst. Year to date, the board has filed 9 accusations or amended accusations, 1 accusation and petition to revoke probation, 4 citations, 8 public letters of reprimand, 7 decision and orders, which include probation, 1 surrender, and 1 revocation. As you can see, enforcement is taking more action in comparison to last year. Now to talk about probation statistics. We have 7 new probationers that were added these past 2 quarters, ending with a total of 36 who have been placed on probation for various causes. Of the 36 probationers, 8 are tolling out of state and not receiving credit to the completion of their probation. Of the 36 licensees on probation, 4 are participating in the board's diversion program as board referrals. In addition to the 4 board referrals, the diversion program has 6 other licensees participating in their program as self-referrals. As previously stated, one accusation and petition to revoke probation was filed in Q2. At the request of Ms. Pines in the last board meeting, we ran some reports and have drafted the attachment, the subsequent attachment, which is attachment 12B. This is a list of all of our violations for each of our probationers, so you can take a look. It was not only requested to present these violations to you for review, but also to determine what some of the common violation types are. And as expected, given some of my experience in other boards, the top most common violation types are gross negligent, repeated negligent acts, and unprofessional conduct. At this time, this concludes my report, and I'd be happy to answer any questions you may have.
Thank you. Are there any questions from board members?
And Michael Kenotes, legal counsel, just interjecting very briefly that member Adamian and member Jensen have joined us and are on camera. Thank you.
Thank you. Any questions from board members? Dr. Luzak?
Ms. Calderon, can I ask you to take a look at 12A, the transmittals to Attorney General? So maybe everybody else understands this, I don't. So transmittals to Attorney General, is that after completion of desk and field investigation and in addition to that time?
That is correct, Dr. Lusek. So the top categories, PM1 is obviously your totals. PM2 is the intake as far as initiating the cases. PM3 is the timeline for desk investigations, including HQIU staff. And then PM4 is what it takes for the Attorney General to file the accusation after the completion of the investigation.
So PM4 cycle time, that's just at the Attorney General, or that's?
No, it's a grand total.
Oh, that's a grand total.
It's a grand
So
total.
grand total, just a little under 3 years?
1052 is the cycle time right now. That is correct. And again, this measure encompasses the services from the Attorney General, the negotiations between attorneys and myself, in addition to the Office of Administrative Hearings if our cases go to further, hearing proceedings.
And I see a target of 540 days. So
Correct.
Is that the grand total? PM4 target is 540?
Correct. That should be from intake all the way to completion of a decision and order. So as I mentioned in PM4, that's the area that we sort of have very little control over. But if we try to work on our other performance measures and bring those numbers down, the hopes are that in general, by the time we get to our PM4s, we can meet that target of 540 days. So the sooner we complete our desk investigations, the sooner we have our HQIU staff complete their investigations, those cases will get transmitted a lot faster, and in turn, we can meet our Attorney General goal.
So our goal for the complete investigation to a decision is 540 days?
Correct. And that is set by department standards. So we actually do meet with the department and set those standards based on what we have in-house and our own personal, goals. But for the majority, this is kind of standard for all healing art boards. Just
I
kind of-
absolutely understand that there's a large backlog of aged cases, and appreciate your diligent efforts to work through that backlog.
Thank you.
Any other comments on the enforcement and probation unit updates? Members of the public who are present, any questions or comments regarding this agenda item?
This is the moderator. Dr. Jensen had her hand raised.
Oh,
not
I'm
sure if she-
sorry. Dr. Jensen, I apologize.
That's okay. Most of my questions were answered as Ms. Calderon was answering already.
Oops, okay. No members of the public present wish to comment. Any moderator, anybody, members of the public online wish to comment on the enforcement and probation unit updates?
Thank you, Mr. Board President. If any member of the public would like to comment on agenda item 12, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We are displaying instructions and will give you a moment. All right, this is the moderator. I see no request for comment. I return the floor back to you, Mr. Board President.
Thank you. We'll move on to agenda item number 13, which is the presentation from Maximus on our diversion program. Now we have Virginia Matthews, the program director.
Yes. And also with Ann Morales, who's presenting with me. Here we go. Oh, she was there a minute ago. And you can see my PowerPoint. I can see it on the screen.
Yes, thank you.
So I'm Jenny Matthews. I'm the program director of the recovery programs for California, and we can go ahead and advance the slide. And I'm the project director, and Ann Morales is with me. She's the clinical case manager for the Osteopathic Medical Board. And Ann, we can see your background, but we can't see you. Oh, you disappeared completely. So while she adjusts that, I'll keep talking, and hopefully she'll get her camera figured out. So Maximus has a contract with the Department of Consumer Affairs. I'm going to give you about maybe 8 to 10 minutes of a little bit of background information, and then we're going to talk about the program specifically. So I'm going to give you a little bit of general information first. So we have a contract with the Department of Consumer Affairs. We work with 8 healthcare licensing boards. The Osteopathic Medical Board is one of them. I'm sure that you're aware of the medical board not having a program. So in California, the physicians that we work with are the Osteopathic Board. We work with the Veterinary Board, Physician Assistants, the Dental Board, Dental Hygiene, Board of Registered Nursing, which is the largest of the boards that we work with. They have about 75% of the participants that we work with. The Board of Pharmacy and the Physical Therapy Board. So those are the 8 medical boards that we work with, the 8 health professional boards that we work with. Go ahead and advance. And want you to understand our philosophy and how we work with it. And probably the biggest takeaway from what we're talking about, which is that substance use disorder is a disease process. We recognize that. And we approach it that way. So we're not enforcement. We don't approach it as enforcement, but we do approach it from a recovery perspective. We recognize the features of substance use disorder, that there's a strong genetic influence, the chronic relapsing brain disease, comparable relapse rates to diabetes, cardiac disease, or asthma. Sometimes permanent brain changes, brain chemistry changes long-term, and strong effects on the pleasure centers of the brain. And those realities are, as they research and turn over more and more, becoming more and more evident. Go ahead. And advance. NIDA back in 2014 identified relapse rates for substance use disorder, drug addiction being comparable to diabetes, hypertension, and asthma, to, as I mentioned, other chronic relapsing diseases. It's right in there with them at somewhere between 60 and 70%. So we recognize that, and we recognize that when participants come into our program, there's a likelihood that they're going to relapse sometime in that early stages of entry into the program. So it's not a character flaw or a weakness, but it's the powerful addiction that they're dealing with, and we recognize that it's the effects on the brain chemistry. And it requires support and active engagement in the recovery process, and that's what we do with our program. Go ahead. The recovery program in California, we have a 12% relapse rate in the first 4 years of participation in our program. So as I mentioned, the general population runs around a 60 to 70% relapse rate. That's a generally accepted statistic in the industry. And so we know that our relapse rate runs at 12%. That is, again, is evidence of the support and the case management and the coaching and the monitoring that we do with our program. We also know that the incidence of substance use disorder in the general population is comparable in healthcare professionals, which runs somewhere in the 10 to 14 to 20% range. So we're right in there around 14 to 15% range for healthcare professionals. Go ahead. And ASAM, the American Society of Addiction Medicine, defines addiction as a treatable chronic medical disease involving complex interaction among the brain circuits, genetics, the environment, and the individual's life experiences. And people with addiction use substances or engage in behaviors, so it's not just substance use, but also behaviors that become compulsive and often continue despite the harmful consequences. So they know that there are harmful consequences. They recognize the negative effects of their use or behaviors, but they are unable to stop. And so that's the continuation of that use of the substance or the behavior. Prevention efforts and treatment approaches for addiction are generally as successful as those for other chronic diseases. Go ahead. And why does the brain like opium more than it does broccoli? Well, it's because there are so many of the very, very powerful neurotransmitters that are involved with addiction, primarily dopamine, but the other endorphins, GABA, norepi, epi, serotonin, acetylcholine, the enkephalins, and those effects on the brain. Go ahead. So how to diagnose addiction, the diagnostic criteria for substance use disorders from the DSM. They're now recognizing it on a spectrum, mild, moderate to severe, and recognizing that those symptoms using more or longer than planned, so that those attempts to stop or quit, wasting time pursuing, taking the time when other efforts might trying to do other things, like taking place of working, taking place of other efforts, cravings, neglecting other duties, interfering with their relationships, giving up activities, exercise, meetings, friends. So the pursuit of the behavior or the substance takes the place of other things in their lives. Dangerousness of the use or the behavior, continuing to use despite the harm, tolerance, and withdrawal. So the physical dependence isn't as much of an issue. That goes away after a few days. It's the psychological dependence and the effects on the effects on the brain and the psychological dependence, which becomes more of an issue over the long term. Go ahead. Two key factors for healthcare professionals, it's the attitude and accessibility. Go ahead. So attitude, first of all, it's for themselves. Healthcare professionals tend to be outward focused with little self-care. They're really more focused on the patients for the others and reluctant to identify a substance use disorder in themselves. There's a lot of shame in any addict, in any person who's afflicted with a substance use disorder. Shame is a big issue. For healthcare professionals, it's multiplied. Denial, again, same thing. That denial is a big component of a substance use disorder, but when you're a healthcare professional, you just can't believe that it could be affecting you, and they feel immune to it. Go ahead. The attitude about medications. We handle powerful medications, substances every day. We see the effects, the intended effects, and we become insensitive to the power of these medications and become insensitive to the side effects of these medications because we recognize and also believe that we know better, that we understand them from the inside out and can manage them a little more powerfully than the general public. Go ahead. The accessibility. Substances are poorly controlled in many settings, especially surgical suites and in doctors' offices, although these days you don't see the availability of samples like we used to in the offices, but surgical suites, hospital settings, the accessibility is still there. The narcotic waste policy is not consistently followed. And we're still seeing people writing prescriptions for themselves or for others with other names on them, and then fulfilling the scripts for themselves with someone else's name. Go ahead. And as I mentioned, the little self-care, reluctantly identified shame, denial. There's high stress work, especially with the pandemic, as we all know, and we've all heard about. The physical and emotional component of the work that healthcare professionals do is taken a toll, and we've seen an uptick in reliance on substances to cope with the stress, physical and emotional, and the belief that drugs and alcohol are okay to cope. Go ahead. So to recognize diversion or substance use in healthcare settings, there's a change in the drug ordering or administering patterns. We'll see the professional in the office or in the facility at odd hours or on their days off, and the staff or the office staff will begin to notice that there are odd behaviors or that their coworkers are showing up at odd times, leaving the office to go out to their car, take breaks at their car, or go to the restroom for long breaks, or being gone for long lunch hours. And complaints from family members and patients that they're not getting relief from their pain meds, that there's something not quite right, and it's because the pain meds aren't making it all the way to the end to the patient. Go ahead. This is a statistic that comes from Dr. Skipper and McClellan Campbell and DuPont from a study that they did a couple of years back. They know that alcohol is 49% of the substance of drug of choice abused by physicians. So even though we tend to think it's diversion of opiates or diversion of maybe benzos or sedative hypnotics in the workplace, alcohol is still the big one. We see that in relapses in our program as well. Alcohol is still the primary drug of choice that we see, and opiates come in second. And then, as you can see on the slide, the other drugs are following kind of a distant behind that. We're starting to see some other kind of odd drugs out there, things like kratom, because it's available. You can buy it easily in stores now. Kombucha, salvia, some other drugs like that that are available either on the internet or in boutique kind of stores, smoke shops. And so we're beginning to see those become more popular right now. And marijuana, because it's relatively easy without, obviously in California, recreational as well as medical. So we're seeing cannabis. Go ahead. And then I'm going to turn it over to Ann. So this is yours, the mission of the recovery program and what we do. Go ahead.
So our mission within the recovery program is to assist the healthcare professional back to practice and back to engaging in a recovery program. Our job is to protect the public. So that is made clear to each participant at the beginning of their enrollment in the program, so that they have an understanding of what the end goal is within our program. Next slide, please. What is the recovery program? The recovery program is a program for healthcare professionals, so licensed healthcare professionals in our case, who are suffering from substance use disorder and or mental health illness. A lot of times what we're finding is the two do go hand in hand. And we're a monitoring program which provides ongoing support and case management. The case management portion is highly individualized. It meets the needs of each participant, and we are not a treatment program. We may direct the participants into a form of treatment or into treatment, but we do not tell them where to go, nor do we tell the treatment provider what they need to do for each participant. That is individualized and between the participant or the physician in the osteopathic board's case and the individual treatment program. Next slide, please. What is a physician healthcare program? There is a Federation of State Medical Boards that defines a PHP. The PHP is a confidential program of prevention, detection, intervention, rehabilitation, and monitoring of licensees or those trained with potentially impairing conditions approved and recognized by the State Medical Board. And the physician programs are fully described in the 2020 guidelines of the FSPHP programs. Ginny and I are both members of the FSPHP, and if anyone's interested, we could direct you to where you can find those guidelines. Next slide, please. Benefits of the physician's healthcare program include education, early intervention, and prevention. PHPs can act fast because they are clinical. No due process required when the doctor cooperates. Doctors cooperate with PHPs because PHP is confidential, compassionate, and eliminates the need for the legal process with the medical board. Our osteopathic medical board follows the diversion evaluation committee model. A committee made up of peers supported and directed by the Osteopathic Medical Board include currently 5 physicians on a panel that interview the participants on a frequency determined by that panel. Next slide. The application process. We have several different types of referrals within the Osteopathic Board. The referrals are probationary referrals. The participant agrees to participate in the diversion program as a term of their stipulated settlement with the board, or they're a self-referral. The participant contacts Maximus and requests to join the program. In each of the cases, the board is made aware that the participant is enrolled in the program and the case is managed in the same way. Next slide, please. The intake program steps, there's several steps to the initial intake. We do an intake assessment on the phone. Sometimes, if need be, we can do these intake assessments via Zoom. We do a clinical assessment, which is an in-person with a licensed clinician. That is at no charge to the applicant. It's the entry into treatment as recommended. So the clinician who does the initial assessment will make some treatment recommendations. The participant communicates weekly with the Maximus team until they're seen by the committee. And then they check in with the team, with the case manager monthly. Next slide, please. There are community-based support meetings which the participants are directed to. They can be any 12-step meeting of their choice. We do not select the meetings that they attend, but we make available the meetings that are out there for them. Initially, they start to attend meetings daily, 90 and 90. It's very common, so that they can get meetings under their belt and understand which meetings meet their needs, their individual needs. There's also a peer support group that they attend either once a week or twice a week, depending on the recommendations of the clinical assessor. They're led by a licensed clinician. They do a monthly self-report where they document how things are going for them, put any pertinent needs that they may have or want to address with the case manager, as well as identifying a sponsor or an accountability partner. They check in with their case manager weekly until they're seen by the DEC, and then it becomes a monthly discussion. Next slide, please. The Diversion Evaluation Committee is a model that is unique to California. It's used by 5 of the 8 boards. It formally reviews and accepts the applicant into the program, and it formulates a participant's ongoing recovery plan. The participants do come to those meetings, and they meet with their committee, and they share what's going on with their life, as well as they gradually make requests such as returning to work. The committee develops and formulates a plan on what that's going to look like. And they work together with the participant to help support them through the program. Next slide. Random drug testing. Random drug testing is also a part of their program. There's flexible drug testing options. We get reliable results from a certified lab. We do have sensitive cutoff levels. We do not share those cutoff levels with the participant. We don't use point of care testing. Point of care testing could be as simple as buying a urine cup at the pharmacy and then using a dipstick. Our testing is more advanced than the point of care testing. We use varied collection methods. We do also offer, if need be, video collections for remote or homebound participants. And also, currently, we're looking at the option of DNA methods that prevents tampering. That's become a new and upcoming modality for testing, and it's something that we are seriously considering at this time. Next slide. For random drugs testing, there's a daily check-in with the lab provider. They either use a mobile app or a web check-in. When selected, they must test on the same day. We use extensive test panel with low cutoff values. It's highly sensitive. Urine is the most common sample collected, but there can also be saliva, hair, and blood. Forgot to add that we also can do a nail collection if needed. ETG and ETS tests for alcohol metabolite in the urine. It gives us approximately a 3-day detection. We use the PEth blood tests for alcohol metabolite in the blood, and that's approximately a 3-week window of detection. The hair test for multiple substances, it's approximately a 3-month detection window. And we're not currently using the breath Sweat, or SoberLink, but it is available and it's something that we could add if we needed to. Next slide. Return to work. Each participant must apply to the deck to return to work. The deck evaluates their readiness. They consider compliance with the program requirements. Drug testing uniform standards require at least a minimum of 30 days of negative drug results prior to return to work. We also follow the recommendations of the support group. The participant's own report of progress and readiness to return to work. Each participant is asked to complete an essay including a relapse prevention plan and an analysis of the potential triggers in the workplace. Next slide. Returning to work, the participant demonstrates that readiness to return to work. They self-report their progress, examines and determine any risks or triggers within the workplace, the history and support system, and also a review and an overview of their relapse prevention plan. The case manager evaluates that readiness by considering all things: compliance with program requirements, drug testing, and recommendations made by the support group facilitator. Return to work. When a job is offered, they must identify a worksite monitor. The participant must sign appropriate release of information consent forms. They must have an agreement signed by a worksite monitor. That worksite monitor is contacted as well as the employer, and they're educated in the process of the return to work within the healthcare professionals program. We're open and transparent with sharing signs and symptoms of relapse, as well as encouraging the worksite monitor and employer to ask for any questions that they may have. Maximus provides the training to the worksite monitor. That training is, we provide a video as well as verbal discussion with those worksite monitors for that return to work. They submit an org chart to demonstrate that the worksite monitor is at least one step above the participant on an org chart and is not related to the participant and not an employee. And if they're in solo practice, they find another professional to monitor them with random unannounced visits to the worksite to monitor for safe practice. They submit a job description and submit an affidavit that the worksite monitor meets the criteria, has been trained, and agrees to the expectations of the position. I have had questions in the past regarding how does that work with someone in a solo practice. We meet with the participant and discuss what that looks like and ask them to provide us a neutral party who, if they missed a check-in call for work or if they had a positive drug test, would have the responsibility and ability to remove them from practice. So we do explain that process up front so that it becomes a streamlined process that we can follow. Next slide. The intake assessment is at no charge to the participant, as well as the clinical assessment. The program administrative fee varies, and each DO is explained the cost per month. It's $477. And we do share that information up front with the osteopathic doctors. Next slide. The support group cost varies from $200 to $400 a month. Healthcare costs varies for treatment. Some physicians do have insurance, inpatient, residential, intensive outpatient, substance use disorder treatment, psych evals, medications, counseling, and therapy are often covered by their insurance, and we strongly encourage and support them working with their insurance companies for their treatment. Random drug screening is a per test fee. it's $57.50, and each collection fees varies. And those are also given up front to the participants so they know how much it costs. Next slide. Transition or successful completion criteria. At the end of their enrollment within the program, they're asked to petition for transition. They write an essay examining their life's journey into recovery. We ask them to really put some deep thought and consideration when preparing their essay. We also ask for them to develop a relapse prevention plan. We may also ask them to do a relapse prevention workbook to help them become really strongly entrenched in relapse prevention. We also ask that they get letters of reference from their sponsor, family members, support group, worksite monitors, maybe even someone who supported them within the workplace. The objective of transition is to slowly allow the participant to take full responsibility of their own recovery process while they're still engaged in the program. And the participant is placed on a reduced monitoring for 1 year during that transition phase before being granted successful completion. And each participant demonstrates a manner of living that supports ongoing recovery. Next slide. Successful completion criteria. The length of time in the programs vary by individual case, their history of substance use or diagnosis, and the program compliance. They must have no evidence of relapse within 24 months and to complete at least 24 months of satisfactory participation and compliance. It's a 3 to 5 year total program participation. And recovery works. And I'm maybe a little bit prejudiced, but I think that the osteopathic medical program of diversion is one of the strongest programs within Maximus. Thank you. Does anybody have any questions?
Thank you very much for that presentation. I think it's a very good cause to try to get physicians who fall to substance use disorder back in the community doing the thing that they love and desire, which is to help patients. And sustained recovery, I think, is a huge, huge part of it. I appreciate everything you're doing.
Thank you.
Any comments from board members?
I just have a sort of couple questions. When you first talked about relapse in like the first, I don't know if you gave months or days, just how high that was. So what is it that you do to help that person to get through that early time of relapse? And then that's the first question. And then the 12% that in 4 years do relapse, is there something consistent that you notice of those people when you evaluate them 4 years later and they relapse? Those are my two questions.
Okay. I can speak to that, and Ann, you feel free to jump in too. But so in general, individuals without any support other than going maybe to AA, NA, or going into treatment and then coming out of treatment, and without any additional post-treatment support, because that's what we do is this level of post-treatment support. So without that, the relapse rate runs in that 60% range over the first 1 to 4 years. We know that in our program, we've measured it, and the relapse rate over the first 4 years in the program is 12%. We also know that most of that happens in the first year. It was, I might be a little bit off, but I think it was 85% of the relapses occurred in that first year. And most of those were in the first 6 months because that's when the individuals are the most vulnerable. It's the hardest at that point to really stay away from all of the triggers and all of the cravings and everything that they're giving up at that point. As they're moving away from the substances, the neurotransmitters in the brain are still raging, and it's the hardest to, calm those down and stay away from those. And so we know that that's the period of time when the participants are the most vulnerable. So when they first come into the program, they're checking in with our case manager weekly. They're attending daily 12-step or community support group meetings instead of, as they move farther into our program, it reduces to 3 times a week or maybe 4 times a week, but we reduce the frequency of those meetings. Very often when they come into the program, in addition to those daily meetings, they're going to twice a week health support groups, which is a facilitated peer support group with other healthcare professionals that is facilitated by a licensed clinician. And they start out twice a week, and then that after a year or so gets reduced to once a week. So the level of support is much more intense during that first 6 months to a year and a half. And then as we're watching the progression of the participant, that begins to back off and slow down a little bit, and we can reduce that support. And it's all individualized. It just depends on how the individual is doing in the program. And we have a lot of feedback from them, and we give them feedback on how they're doing. We have them write essays. I wish I had a better word for it. I don't like that we call it an essay, but that's what we call it. But we have them journal and write about where they are and how they're doing. If they do relapse or if they have a positive test result, we have them write about what happened, what were they feeling before it happened, what were the triggers, what could have been done to avoid it, what are they going to do next time not to let it happen. If they miss a call or they have a problem at work, we have them write about that and talk to us about what happened. So it's that level of coaching and support and discussion that the case manager, and that's Anne, that the case manager does with the participant to walk them through those processes and help them use the tools that they picked up in treatment. Because we're not treatment, but we know about treatment. We've all worked with treatment providers, and so we help them to use those tools and bring them forward. It's that post-treatment support is that we're able to provide for them. And jump in. Sorry, if there's anything that you want to add, feel free.
So built in within the Osteopathic Medical Board DEC Evaluation Committee, we have a lot of sobriety and we have a lot of education. Each of the committee members have either worked in substance use disorder treatment centers, or they're part of it, and that they're trained in psychiatrists within that specialty. Each one brings a different gift to the table, if you would. Within the healthcare professional that's highly educated, as are the osteopathic physicians, we may need to determine if they need a more in-depth clinical assessment to help us get to the foundation of their disease. So we may send the osteopathic physician for what's called a 3-day clinical assessment. There's facilities that are trained to look at the multifocal, multi-aspected treatment requirements for the osteopathic physician. That is determined after the first evaluation is completed and after they meet with their committee. Each physician within our committee is given a highly individualized program with a lot of details, depending on their disease and depending on the amount of time that they've been impaired. The determination is made based on that as to the level of treatment. And one of the things that I can say is the committee really listens to the details that each physician brings to the table within their their stories, and they really determine on an individual basis what those needs are, keeping in mind public protection at all time. So to answer your question, each physician has a very individualized program.
Thank you. I have one more question around physicians who enter the program, not having had a problem, there's no disciplinary action, there's no complaint, but they feel that the path that they're on may lead them to that. When they come to your program, are we informed that they're joined the program?
The boards, the Osteopathic Medical Board is informed that they are participating. We don't necessarily share personal information, but we share the information on that they're there and they're being monitored. And if there's any questions that the board may have, because sometimes participants come in and they say, oh yeah, I'm a self-referral, but the reality is they've had a complaint that just hasn't come to light yet. So it does benefit them to self-report and get started.
Thank you.
Mhm.
Are there any other board members who wish to comment? Dr. Luzak?
Thank you so much. You're doing such important work, and it's so pleasing to hear that your success rates are so great. I do have a number of questions, so just brief responses would be probably most in order here. So you mentioned a 12% relapse rate. Is that after completion of the program?
No, that's well enrolled.
Okay. So do you have any figure about how many people relapse after completion of the program?
I don't, but there's a study of physicians. The one slide that I referenced, the DuPont Skipper study did review physician programs, and they have, I think it ended up being 95% maintained sobriety.
So
Yeah.
I'll just share with you, and I'll be happy to share this reference if it would be helpful. But there's a 2021 article in Journal of Clinical Medicine. It's a meta-analysis of 29 other studies involving recovery programs for healthcare professionals. And about 3/4 of healthcare professionals with substance use disorders participating in monitoring programs are abstinent during follow-up and working at the end of the follow-up period. So that's a failure rate of 25%. And this is a very, very difficult disease. It's not surprising. Meta-analyses have the flaw of comparing apples and oranges, but it would be helpful to know kind of long-term after graduation from your program what the relapse rate is. When did Maximus establish a relationship with the OMBC? So when did you start, taking patients from our diversion evaluation committee?
We've had the contract with the Department of Consumer Affairs since 2003, so 20 years.
So that's been with the OMBC as well, because not all the DCA boards work with Maximus.
I believe so. I believe that's been one of the original. I'm not 100% sure, but I believe it is.
Okay. And if a participant in Maximus is the subject of an investigation which has been closed or held in abeyance, and this would be under BCP 2365, if they're a subject of an investigation that's closed or held in abeyance while the patient is a participant in the program and they relapse, how is that information reported to the relevant board?
So
were-
the board,
Go ahead.
Go ahead, Julie. No, go ahead.
We under contract, we report the relapse to the board, but that doesn't necessarily mean that we close the case or do anything disciplinary with it. So we have a series of steps that we take after a participant relapses, and we work with the committee to determine what the next steps are going to be. And so because we expect relapse to occur. So again, each case is individual. So we remove them from work. We have the uniform standards for substance abusing licensees that we're required to follow that came into play in 2010 from Senate Bill 1441 back in 2010. But and so that's put into place some requirements, and one of those is removing people from work for a minimum of 30 days. But so we remove them from work. We typically, if they have a relapse like that or a positive test result, we have them go back into treatment, depending on if they're already in treatment or what's required, what level of treatment is required.
So that comes back to the board through the DEC.
Yes.
Yes,
Okay.
yes.
And then when it comes to the DEC, it's at the DEC's discretion whether that, how that information is transmitted to the members sitting here or, the executive leadership and staff. Is that correct?
That information is given to the executive officer of the Osteopathic Medical Board,
Okay.
and she disperses that information as appropriate.
If I may step in, Dr. Lusak, to elaborate a little bit about the board's role as well. These doctors that suffer from substance abuse disorders, in their stipulated decisions, they have this particular term as one of the terms. There's also other terms that they have to follow. And they're not only being monitored by Maximus, but they're also being monitored by our probation monitor. So in this case, Ralph would be the individual that would be notified along with me. And then the board has the discretion at any given time based on non-compliance issues, if there's a pattern, to file a petition to revoke their probation. So we get notified immediately when there's a non-compliance, whether it's a missed phone call, whether it's a dirty test, a dilute, out of range, all of those notifications come to us. And Ralph, coming from a board that handled all of the diversion program requirements for the medical board, actually has the training to do site inspections. And that's what I'm more excited about bringing him on, is that he's fully trained to, along with the worksite monitors, to go out there and do site inspections, which we plan to implement immediately.
My question wasn't so much about licensees on probation, but licensees who are under investigation prior to there being a decision. So those are the folks that I'm concerned about in the context of our, the long lag time to bring these cases under investigation to decision. So
that they are reported to the board just like someone who is on probation. We are in close contact if the participant were to relapse, if they are a risk to the public. We are committed to follow up on each participant
Got it.
directly to the
Thank-
board. And
thank-
so that
thank
would
you.
include Erica and Ralph.
and then that applies to self-referrals as well. Is that
Correct.
correct? So somebody who, previously has never had any investigation, isn't under investigation by the board and doesn't have any, 805 report or police report, but they self-refer. And if they relapse, then that information is transmitted to the board.
That would be treated as an initial complaint.
Mhm.
We would do a a board informal complaint initiation at that level. With the notification that Maximus has deemed this person to be a public risk based on substance abuse disorders. And so we would treat it as an actual initial complaint that we would look into and move it along for formal action.
Thanks so much. Last question here. Thank you so much for bearing with me. So you talked about return to work agreements and individualization of the plan, recovery plan. So in terms of return to work agreements, I assume that they would be different depending on the practice setting. For example, someone who's a outpatient family physician would likely have a different set of requirements for return to work than, say, an anesthesia provider.
Correct. And also, one of the significant parts of the return to work is the gradual return to work. So what we oftentimes find in some of the osteopathic physicians is they're working a lot of overtime. There's no normal work week defined within their work hours. So the committee gradually ramps them up for that return to work. So they may start off with as little as 10, 12 hours a week, gradually adding additional hours as they demonstrate their sobriety and their ability to really integrate the program into every aspect of their life. Then they gradually start increasing them more and more. And the final phase, that transition phase, they're allowed to do what they think that they would like to do. What we're finding more and more is they're liking the hour limits, and they're liking that regulation of you can't take 1,000,000 hours a call because you can. So we're finding that a lot of times these healthy requirements really extend beyond just that first 4 years and then their transition phase. And the majority of the osteopathic physicians that are in the program do successfully complete after 5 years. And we have some incredible stories of recovery within the osteopathic board that I'm really proud to be part of, and proud to see that they've successfully completed and have made lifelong changes.
I am so glad you're there. I apologize, just one last question. Is your organization's work audited by an external agency?
We are. So we're the only program of this type that's ISO certified, the ISO International Standards Organization. We're actually coming up on our annual ISO audit in the first week of March, but we are ISO certified. We also are due for an external audit by the Department of Consumer Affairs, and I know that they're working on making that happen. So we're waiting anxiously for that to start anytime soon. But yes, we are.
Thank you so much for your work on behalf of the citizens of California and our colleagues.
Thank you.
Michael Kenotes, legal counsel. Just to jump in briefly, and I wasn't aware we would be using the same acronym for two terms, because there was another ISO out there that I thought was helpful to explain in terms of the gap between when someone may self-report to Maximus or just in the ordinary course of business promotes us. It's the interim suspension order.
Yeah.
And that is something that your executive director has in her toolbox, where if there's someone who is an immediate threat to the public for some particular reason, they can bring an action in short order to remove that person from practice, and pending the disciplinary case or whatever situation needs to occur to rehabilitate the person.
Mhm.
Just a quick question. If a physician self-reports to another facility that's not contracted with DCA, are they required to report that to the board?
Some boards have mandated reporting and others don't, and I don't know about the osteopathic board.
Hi, Jenny. We don't. We actually
Okay.
removed some of those questions not long ago from our application process. So I just thought I would point that out that we're trying to make them feel comfortable, to go out and get the help that they need before it becomes an actual problem where there's, patient harm. So those questions have been removed from the application.
Thank you once again for everything.
Dr. Lusak, just to answer to your question that Jenny didn't have an answer to, we did contract since 2003. That we have been under their contract since then.
Are there any members of the public present who would like to comment on the presentation of the Maximus Diversion Program? None? Moderator, are there any members of the public online who wish to comment on this presentation?
Thank you, Mr. Board President. If any member of the public would like to comment on the presentation, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, this is the moderator. I see no requests for comment. Mr. Board President, I return the floor back to you.
Thank you. And thank you once again for a very nice presentation and for all the work you do.
Thank you for having us today.
Thank you for having
Thank you.
us.
All right, we'll move on to agenda item number 14, which is discussion of possible action on legislation. And for that, we'll bring Terry Thorfinson, our Administrative Services Program Manager.
Thank you, President Bahari and board members. Let's dive in. I know it's late in the afternoon, but legislation can be exciting as a topic. I wanted to just go over how this is organized for this agenda item because it doesn't look like it's organized in any logical order. Handout 1 is all of the chaptered bills that were on our list, whether they were positions or watch. And so I wanted to have a detailed listing of not only what the bill does, analysis and implementation. The implementation section is repeated, so I'm not going to go into it. Basically, it's either posting it on our website and sending out an email, a policy alert to licensees. And if there's anything breeze-wise or application-wise, then that would be an implementation item. So you can note in the implementation section of each of the chaptered bills what exactly the board's doing. Handout 2 is a status. It includes some of the chaptered bills, but it's basically the big list of all the bills we watched or took a position on and what their status is. From that handout, you'll notice which ones are chaptered and which ones are still pending. We're in a 2-year session, so anything that is not died as a bill continues to live another day this legislative session. And then there's the list on the agenda. Since this first chaptered bill memo is 20 pages, I picked just kind of highlight the important ones to focus on. Not everyone is on that list. So if you're wondering why the list is not the same, that's the reason. So let me start with in the chaptered bills with the big bill that had probably the most changes and legal changes both to license and enforcement of any bill. And that was the SB 815, and this was the medical board's oversight bill. But as you know, when we took positions on different aspects of this bill, there were very relevant sections that did apply to the osteo board, given the way we're organized in the statute. And so we actively took positions on these items. And because this bill was so numerous, I wanted to, there's just some value in kind of bullet pointing all the things the bill did produce, because there were some things that we advocated for that did not make the list in terms of the final bill. So I wanted to just kind of flesh out that. I know we went over a lot of detail in this 815, but the summary, I'm trying to summarize it just kind of succinctly because there's so much. So in terms of if you look at the licensing changes, it extends the postgraduate training license expiration to 36 months for those issued a postgraduate training license after January 1st, 2024. So that was a big change. For those of you that remembered, when we first created the postgraduate training license, it was 36 months plus a 3-month kind of grace period for a total of 39 months. Then the next year, the legislature changed it to 12 when they changed the eligibility for licensure to 12 months from 36 months. Then that also, they changed the expiration for the PTL to 15 months, which caused problems. So this bill was trying to solve some of the problems. And one of them is people were having problems getting a license within the 15 months if they had a PTL. And so this new change allows for people that are in residency to not even have to obtain a physician and surgeon license if all they want to do is finish residency. And so it sort of simplifies, giving them that option, takes that, stress, or issue away for those that want to practice in California. They can get an early start at starting at completion of 12 months, but they don't have to. They'd have the whole 36 months to do it. So I think it's a win-win in terms of what the board observed problems with the changing of the expiration dates and the stress it put on residency programs, because what we did see, and even the Department of Consumer Affairs Director had to suspend the law, is we did see people having to cease practice. So this extension to the 36 months prevents that ceasing practice pressure on residents that didn't obtain a physician and surgeon license. The next change was to eliminate the 24 months in the same residency program requirement for completion of the 36 months postgraduate training. This this was one of the requests the board approved that we submitted. And what we basically were advocating for is the elimination of the 24 months in the same program, because we didn't observe any real value added or competency to it. And what we did see is that for some, not a large number, it precluded their eligibility for a physician and surgeon license because, and I will take surgery for an example, there are certain specialties where it's natural for residents to jump around from different programs. And the board felt that for competency purposes, that would be improved competency. And it was in weighing the idea, the 24 months assumed, sort of without evidence, that if someone was in a program for longer, their faculty and oversight would get a better feel for their real competency. And so that was the reason for the 24 months. But the board didn't see any problems with that, competency issue. And in fact, people that sometimes did do an extra year residency in California to meet the 24 months, there was no competency issues at all. The legislature agreed and eliminated that requirement. And then we talked about how there was an issue with the demonstration of SB 806 compliance, where when they changed to the licensure requirement to be able to be eligible for a license after 12 months, they still wanted to retain the completion of 36 months of residency. Okay, so now they switched that to the renewal And we had problems with people getting that done. So the legislatures granted an additional 60 days from when their license would expire to complete that demonstration of completion of 36 months. So that's good. And then you heard from other board meetings, but it's also a change is it postpones the board's oversight to 2028. And I think part of the thing was very well demonstrated when in kind of mid-session, we became very active in this oversight bill, even though we weren't up for oversight. And we had been in the past. And so I think the committee felt very strongly we probably should resume the two boards going into oversight together, because we would have been in the same bill if we had, instead of kind of walking our way into this oversight bill. So, so we don't go up for oversight until 2028. Okay, so now enforcement changes. These were to characterize what the boards were asking is, I think the medical board, which I give great credit for kind of thinking through the criticism of their whole enforcement process, if they could change things to streamline or lessen the time frame for start to finish enforcement, what would those things be? And this is the laundry list. Not everything got passed, but it's a pretty good laundry list of changes. Board requires an establishment of a complaint unit. That's for both boards. That includes staff and a new kind of process, which would be that enforcement staff would be interviewing complainants. And in the past, both boards may have interviewed episodically, but nothing was systematic, and probably because of it's time consuming, there would be additional staffing needs. So now with this new establishment of this complaint unit, it would allow for the board to be interviewing complaints. And so there would be that increased kind of connection in terms of the complaint process, and we'd have the staff to do it. There's a second change is it authorizes the executive director to adopt default decisions, stipulations for surrender of license, and automatic revocations. Typically, the board has most of the authority to approve decisions, but in certain cases that are not deemed to be necessary, default decisions, there's really no discretion in those. And to allow that delegated authority from the board to the executive director would speed that up. Stipulations for surrender, again, no discretion because it's a stipulated surrender. And then automatic revocations where the board has no discretion to involve themselves in the outcome of the decision. So those three have been delegated to the executive director, which I think is logical and will streamline her ability to finalize enforcement actions. In cases with licensees' refusal to comply with subpoenas, subpoena has always been an issue for delay. And, when you've heard from enforcement or even the AGs talk about cases can be complex, subpoena is part of that complexity, and it causes significant delays. So one of the things that it could have been used for, which the legislature was very open to, was delaying the statute of limitations because it still would run. So we would be going through and asking for these documents officially through a subpoena, and the clock is still ticking. And there's and the clock is still ticking for the statute of limitations. So they moved up when that tolling begins, which is the clock stops ticking on the statute of limitations until there's resolution. And it's earlier on than the subpoena order. It's at the beginning when the judge starts to get involved and says to the defense or respondent, why are you not complying with this subpoena, show cause? And at that point, earlier in this process, that's when the clock for statute of limitations stops ticking. So for the board's perspective, that's huge. That will be a huge delay tactic that contributed to statute of limitation loss that won't happen again. So that was great that went through. Okay, pharmacies. We found out, our medical board found out that the Board of Pharmacy, when they asked for records, they got them in 3 days. And we were waiting and waiting and waiting. So we said, hey, why don't we have the same amount of time for records? And so we granted with a process for exemption and the board's involvement, and if there's an extension needed. So that will, I think, since pharmacy records are often a big central part of cases, that should also streamline cases. Automatic suspension. I think we've seen this. This is kind of a theme. The legislature wants particular offenses to be treated so that there's no discretion in what the outcome is. Automatic revocation is what that category is, and it seems to be continually expanded. This year, it's expanded to include sexual abuse, but sexual abuse for BMP codes 726 and 729. 729 was a little bit more serious in terms of the violations or the actions in that. 726 was considered a milder version of sexual offense, but those two are both together and both deemed to be auto revocation violations. A violation of Penal Codes 2090 C and D, serious of felonies defined in the Penal Code, selling, transporting, furnishing, administrating, giving, possessing with the intent to sell, furnish fentanyl. So fentanyl, because of the overdose epidemic that we're seeing, one of the first tools that the government has is to limit its supply. So they're adding this as one of those offenses that would be deemed to be trigger auto revocation. Another area, repeals the controversial BMP code section 2270. This one was prohibiting providing misleading and false non-evidence-based information related to COVID, and this was repealed. So that law no longer exists, and that was included in 815. And then the next area, they modified the probationer's petition for modification or termination. I think the board has seen a lot of petitions that take up the board's time and money to perform, that are basically asking to either modify or terminate their probation earlier than they agreed upon, which kind of can rub people the wrong way when you think, hey, you agreed to 5 years. 5 years is 5 years. You're coming to us at 1 or 2 years. And so what they did is both the medical boards and our board had talked about the need to modify that. So people really were forced on probation to serve a good amount of time, at least the majority of what they either were ordered to or agreed to. And so there was some modification. I'm not going to go over it specifically because there were so many exceptions. It's hard to, it's hard to go over, but it's there for you to read in terms of the modifications. And they also agreed with the request, because the petition is a kind of a black hole for enforcement. It didn't come with any fee, didn't come with any revenue, but it did take up board time, and it did take up ALJ and the stenographer's time, and a lot of people's time and expense. And if it was being done prematurely, it was just one of those costs that we felt that should either be slightly offset or at least have some revenue. The agreed upon language is that we would we would promulgate regulations that were based on reasonable costs. And I think if you recall, when Erica presented this, it's not going to pay for all of the expenses, but it would defer some. And that's yet to be done. Regulation that will come before the board, like other regulations, to discuss reasonable cost and what the mechanism would be to be proposed. But that's also something we asked for. And then finally, the exchange of information between parties should be completed no later than 90 days, changed from 30 days. They felt this was something that was a problem and didn't necessarily lend itself to reaching stipulated settlements, because if both councils didn't get to see, so to speak, the strength of the evidence that the other party had, they might wait longer to decide, maybe I do want to settle or stipulate. So they felt that this was a good overall justice thing that would promote settlement and understanding of each other's strengths and cases. So basically, the idea behind these were the committee was open and asked both boards for ideas on how to change licensing, which we gave them. Both boards did, and they were open to it and made those changes. And they, as I mentioned with the medical board, they said, here's what we evaluate, what we need to streamline enforcement. And for the most part, the committee put that in place. So 815 is a huge bill. It's also involving staff. We were given 3 staff for that bill, and we had one in the process. We had one of those taken away, so we'll have 2 staff to implement that complaint unit. And overall, probably the biggest year for changes that benefited both licensing and enforcement. We may never have a year like this again, but huge. I mean, usually you only get one change, one bill. Okay, so that was the biggie.
Terry, before we go on to the next bill, I just want to make a point of clarification. This law does not require us to interview every single complainant. The complaint liaison unit is, their main function is to be there to answer questions about the complaint process, the enforcement process. That's one component. The second component that Terry mentioned with the interviews, that's any quality of care case that gets closed at the recommendation early onset with the consultant review. If they are recommending that there is not enough evidence here to pursue a formal investigation, that is when we are required to contact the complainant to see if there's any missing information that we can gather from them that would reopen that case so it could proceed with a formal investigation. So just wanted to kind of clarify that. The third component is that we're required to take an impact statement as well. So that earlier when I mentioned that we were revising some of the status letters, one of the status letters that we have right now, which is notifying the consumer that the case is moving along to a formal investigation, will have a paragraph in there indicating if you would like to submit an impact statement, this is the time to do so. So it's going to be gathered up front before it goes to formal investigation and assigned to an investigator. So a couple of, just wanted to clarify those things, that we're not required by law to interview every single complainant. It is just those that are in the early stages as they're being reviewed, the quality of care, and the recommendation is that there's not enough evidence to substantiate a formal investigation. We are to go back to that consumer and gather more information if needed.
Okay, and now I want to skip in my handout 1 to page 13 to go over SB 143. This was a budget bill that had 3 things that involve us in it. It had other things that it funded, but it also put language in. It put language in that extended the postgraduate training license expiration for those that would have expired in September under the old rules of 15 months. It extended their expiration to March 2024. And the reason this was needed is because 815 didn't go into place until January 1. But we had licenses that were in peril of ceasing practice as of September. So that was 3 months where 815 wouldn't have applied. And so the committee took the initiative to add this language to bridge that gap in terms of the expiration date for PTLs. The other thing was, although we don't get the advantage of it because now it expired in January 1st, 2024, but I wanted to highlight there was, and I'll talk about it more in the open meetings, there was a reprieve, an extension of the hybrid system where everybody didn't have to meet in one location up until the first of this year. And that hybrid allowed us to continue with that. The hybrid system allowed us to continue to do board meetings more virtual like we had during COVID. And that particular hybrid went into effect in September, just for a short period of time, 3 months. And now that is done. And then the third major change was the military reciprocity law. I don't know how much we talked about this at board meetings or how much exposure you had to it, because it was the result of Public Law 117-33, which was a federal law. It was brought by the Veterans Administration to create a system of reciprocity licenses from state to state, so that if you were a military or military spouse, you would be entitled to practice, the goal was, in every state, but mostly you had to, because you had to have a license in order to practice, there needed to be some state law that was created. The Department of Consumer Affairs negotiated this on behalf of all of the boards in terms of language, and the way they achieved the implementation of this law is that all of the federal military personnel that would be eligible for this to practice medicine without a license is required to register with the board, and that register must be completed, and then that registration would be the board's, also confers on the board jurisdiction over those people, even though they don't have a license that's issued by this board. So kind of a little bit weird. It's not a total licensure exemption, but the board is not issuing a license, but the board's jurisdiction is based on this negotiated registration. And so beyond the registration, they don't have to, give us anything. If they're in the military and they're licensed in another state, they can automatically just practice medicine. And we know about them because they're required to complete this registration. So this is kind of a disturbing trend of legislation. There's another one that also exempts licensure. Disturbing trend. This one was coming down from the feds, and in federal law supersedes state law. So this one was something that neither the department nor any of the boards really had a choice in, but just to get in and negotiate the best possible arrangement for boards and public safety. That means jurisdiction, because typically without licensure, the board lacks jurisdiction for enforcement. And so without jurisdiction, there's no action the boards can take. So this was negotiated to sort of avoid that, but people don't have to get a license to go through the application process. So that was also big. We'd heard rumors of it, but until kind of late in the season, we didn't really know what the specifics were. So I wanted to provide that kind of detail for you. Okay, so let's go back to page. Okay, page 4 of the chaptered memo. SB 345 Skinner. This is one of the 2 bills that was in response to the elimination of Roe v. Wade and the increasing criminalization of physicians doing abortions in states where it was banned or illegal, and prosecution of physicians carried a heavy penalty. This bill dove into some of the specifics of what preventing basically physicians that were licensed in California and being prosecuted under laws that for providing services that are otherwise legal in California, they were not to be treated as out-of-state convictions are. Normally, if you are disciplined or have an out-of-state conviction, then the board takes it up and can order you, deny a license, can revoke, can put them on probation, whatever. But based on this kind of an action for providing services that would be otherwise legal in California, boards are prohibited from doing that kind of discipline or look. But there was another element that this bill was trying to prevent, which was to have the executive directors forced to turn over documents for cases against physicians that were also licensed in California, but were being prosecuted in these states where it was banned, is that we would, through a subpoena, we would have to give up information. This bill specifically laid out the requirement that if it was for a case that involves services that are otherwise legal, neither the executive director, the governor, or anybody, any agent would have to comply with a subpoena. And there were some protections for that. But basically that was what they were trying to prevent. So you wouldn't be forced into it. And, from a policy perspective, it was a good one to protect execs because they would be trying to act like they were in California where these things were legal, but yet they were being forced into an otherwise legal transaction that you would think, like a subpoena, they had a duty to comply. So this bill really solved that problem, and I think it did it well. Okay, next up is the open meetings law. I did send you, provide you with a little bit of a written explanation of it. And what I had mentioned it in prior meetings, but I wanted to go over the history so we don't have hopes that this is going to change, even if we do, is that this bill was brought by an author who wanted to put in place the hybrid model. And when he brought it through the legislature, he encountered bipartisan opposition, and it was stunning to watch in committee. The opposition, how strong it was, and it was based primarily on the premise that all public interaction for public policy should be in person, and that virtual is somehow inferior in terms of the interaction. And so they extended it to all public bodies, including this board, is that they prefer, just like elected officials prefer to do things in person, they wanted board members that take the oath to serve as a board member to also serve in person. So hence, there was very little change that in effect occurred in this bill, not for lack of desire or intent by the author, but by strong bipartisan opposition in the legislature. And I don't think that that's going to change. But, the fact that there was a reprieve, as I mentioned in SB 143, what that signals to me is that there is support for the hybrid approach. And, the governor in all of his messages has always been championing government to streamline, use technology. And so I think the governor supports this. I think there's members of the legislature that support adopting this virtual meeting format, but not a strong majority yet. So I think that this is going to be with us for a while because there's a strong feeling that in-person is better. Okay, next one is AB 1707, another reproductive health bill. This is a little bit more narrow. It doesn't deal with
I'm sorry, Terry, what
Yeah.
page are you on?
page 6. Oh, yeah, before I go there, the blue section on top of page 6, which is still part of that open meetings law, I put it down because when I write these, I paraphrase, and it was just so detailed and so unbelievable. I just quoted it. I just gave up on paraphrasing. The visual appearance of a member of a state body on camera may cease only when the appearance would be technologically impractical. You can read the rest, but that is straight from the law. That's how specific this law is in terms of the open meeting. Very strong preference to, if we're going to be virtual, there are going to be strong restrictions about virtual. Okay, so I'm still on page 6. So the Pacheco bill is basically, this bill enlarges reproductive health to include gender change operations, also reproductive in nature, but also gender changing in nature, and that those are also being banned in other states, and physicians are being prosecuted for that. And so this bill says you can't, the boards can't prosecute a physician that performs something otherwise legal in California that would be, that they can't discipline them here in California for that. So I think this bill defines the section, what services they define as sensitive to, that this would apply to. So this bill really does well to lay out, solve the problem with the other states' policy and banning. AB 1369, this is the one that was the out-of-state licensure exemption. It did get chaptered. I'm not going to say anything more than that's a real shame, because it means the board doesn't have any control over what happens in these interactions. And I think that until a patient is harmed and they find out that there is no alternative for them, legally or otherwise, this bill may change in terms of a pendulum, but it was seen as a consumer bill from the board's perspective. As you know, we were seeing it as a consumer protection bill, that we shouldn't be giving out exemptions. And this is kind of a trend that's troubling to me, that licensure is being equated with bureaucracy as opposed to public safety, because licensure is public safety. It is the guarantee that everybody is screened for their competency. So when a patient walks in to an office, they know that their physician is competent, period. And when you start to have all these exemptions, that's not true. So troubling trend with the legislature. And then I'm not going to go over the informational bills, although let's see, I have 883. It's a military bill. That is on what page? Okay, that's on page 18. And this is basically a military program that has people that are enrolled in it, that the legislature is requiring the boards to expedite their license when they apply to be physicians. And let's see what else. 83, 1070 is what page? Okay, 1070 on page 10. This bill changes the supervision of physician assistants by MDs or DOs. It went from 4 to 8. And in terms of supervision, that's the big thing for physicians to know. But it also it kind of changed their scope of what they could do. And the rationale for this bill is that the author was saying there's kind of a gap in evaluating and treating in-home patients, and that it would be better to allow physician assistants who could do that, could actually go in person and be allowed to evaluate in person to some limits the patient. And so there is an extension of scope for these physician assistants, and then the supervision increasing to 8 from 4. And let's see, 16.
Carrie,
Yeah.
Carrie, can I jump in there really quick? So the change in the number of physician assistants that a physician and surgeon can supervise is still 4. It only goes to 8 in those situations where they're performing those duties of
The home.
the in-home. Yeah,
Mhm.
I could give more detail on that.
Right.
if you would like.
Yeah. Yeah, it was a complicated bill. I wrote a lot that I'm not going over because it was very complex. Usually a lot of times these bills giveth and taketh in terms of exceptions. And yes, Michael, you pointed out one of the exceptions wasn't across the board in terms of increasing. Okay, on page 13, AB 1646 is a guest rotation abortion training program. This was brought by Planned Parenthood to deal with the reality that red states that are banning abortion have medical schools and residencies in their states that would also be banning the training for abortion services. And as I understand, ACGME training requires abortion services, so it puts those residency programs and potentially medical schools in a bind because they can't train something that's a banned procedure. So in order to fix that, California stepped up to the plate and said, we're going to allow people to come into our state, not require license, including not require postgraduate training licenses for up to 90 days, no paperwork. You just go directly, find a residency that will offer the training program, and they match in that respect. And so the idea is to fill the gap in training that won't call into question the accreditation of these residency programs who are not otherwise able to complete all of the accreditation required training. And let's see, 770 cures. Okay, so the cures, let's see, 1731, page 15. Healing Arts Bill, cures database exempts ER docs from reporting for cures. I think based on the fact that they're not tracking a patient, there was a belief that it's necessary for emergency care for a physician to be able to prescribe on the spot without having to do all of the administrative work. So that was what that bill does. And okay, I went over 345. Okay, last bill is 372, which is a bill that requires the boards. Let's see, I think this is the last page. There's 372.
16.
Huh?
Page 16.
Page 16, okay.
19, I think.
19,
Oh, I've got a
yeah.
different one. Okay.
Okay, yeah, page 19. So SB 372, the author was wanting to allow for health professionals that wanted to change their gender and their name to be able to do so and sort of erase their former gender and name. And so this bill requires the departments and the boards to come up with a method that would do that. And so the license search, to implement this, the license search would one day have one person's name and may have their gender. And then the next day would have a different name, same license, and maybe or maybe not have gender. They would have that option to not disclose gender. Demographics are optional anyway. So the problem the boards had is, how do we track an individual that changes their name completely? And so DCA is working with the board. They developed a database and a modifier system. So we're able to, through the application process or the change of the name and gender process, add a modifier that internally, confidentially, we can track a person, particularly for discipline. We didn't want to have loopholes created for somebody just because they changed their name and then they have a complaint. We can't track their name historically, discipline-wise. So DCA has saved the day in coming up with the electronic Breeze solution for allowing us to be able to do that. And so that bill mandates that name change and gender change.
Just to point out, we actually went live with those changes already. So the portal has been developed. Instructions have been given to all the boards for both this one and the military. So we do have a tracking system already in place, and full implementation has started already with that. There is a lot more information on our website. We have posted information there. There was information that went out with our serve list. So we are trying to actively put out the word that this is a process that, they can apply for, and what the requirements are. And all of that can be found on our website.
And amazing that this is January, so the bill went into effect January 1, and DCA already has this in place, both modifiers and in terms of the information. So kudos to DCA for implementation. Okay, now I want to turn to handout 2.
Terry,
Yeah.
can we take a quick 5-minute break?
Yes, yes.
Okay, before we continue, how do you want me to?
So we'll have to go into recess, and the moderator can provide the timing on
Okay,
the.
so we'll go into recess for 5 minutes. All right, we'll go ahead and have a roll call to begin this last session, hopefully.
Okay, Gore Adamian,
Present.
Dr. Buhari,
Present.
Dr. Jensen,
Present.
Dr. Luzak,
Present.
Andrew Marino,
Present.
Dr. Patel,
Here.
Denise Pines,
Here.
quorum established.
All right, we'll go back to agenda item 14, so Terry Thorpenson can finish.
Okay. Even though it sounded like I was long-winded and this could go on for a long time, I'm actually close to the end. So in going to handout 2, I have one bill that I'm going to talk about, and that's why it's on the agenda. And the rest I want to emphasize is a status bill, but to call your attention to anything that's pending is live in the session. So this is the bills we are interested in. So there are bills of interest here that are going to be still alive. The most interesting one for us is AB 765. That's the title protection, as some people call it. That's the bill where they're trying to get rid of confusion among consumers based on a lot of titles that people use in the healthcare profession. But we have a little bit of a glitch when it comes to the word osteopath. Osteopath was one of those words that was in the statute originally, and then it got removed based on a legislative request. And we have yet to fight that battle this session. So this is our only, going into 2024, our only bill that we have a position on. So we are authorized to still continue to lobby that particular bill. And what we're going to be meeting with the author, but the author is not the problem. The person who is requesting the author take out the osteopath is the problem. And so we're going to have to meet with multiple legislators and committees to try to get osteopath back among the listed protected titles. So I emphasize that because it feels like usually we're done, but we do actually have one very important bill, this AB 765, to fight another day. The difference, I will add, I think the OPSC has indicated an intention to introduce potentially a title protection bill. What's the difference? Well, the difference is this bill has a very strong author and very influential author. And so this is a time when we should really put a full court press into getting osteopath back into that statute. Depending on what kind of an author comes in the next time around, it could be just a fresh slate because it's, a fresh bill and it's only about that one title. This bill is embattled with other professions that are also unhappy with titles that are getting left out and allowed. And so the author pulled it from last session because he knew he needed to get, consensus going forward on issues that were raised. And he was disturbed that he raised the ire of the Osteopathic Medical Board. So that's one that we still have on our plate. And with that, that is my legislative report. Any questions?
Any questions from our board members? Any questions from members of the public who are present or in the room? Seeing none. Moderator, are there any questions from members of the public who are online?
Thank you, Mr. Board President. If any member of the public would like to comment on agenda item 14, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, this is the moderator. I see no requests for comment. I return the floor back to you, Mr. President.
Okay, let's move to agenda item number 15, which is discussion and possible action to discontinue the printed pocket license. And we'll give it over to Machiko Chong, our license program manager.
Hello again. Sorry. Okay. So the next item we are bringing to your attention for possible action is the discontinuation of printed pocket licenses. The Osteopathic Medical Board is proposing to make license verifications more effective for its consumers and licensees. OMBC would like to take the necessary steps to eliminate the issuance of pocket licenses upon initial licensure or renewal for the reasons discussed hereafter. First, we'll discuss consumer protection. Initially, the primary reason for issuing a pocket license was to provide a means to verify the status of a physician and surgeon's license at any given time. At one point in time, this was the only way to verify the license of the status of a license, aside from calling the OMBC. When online verifications began in 2005, the OMBC continued to issue pocket licenses as an online verification was not as widely accepted as an official record. The pocket license was considered the primary and most reliable source of license verification. However, online services have become a standard, cost-saving, environmentally friendly, and reliable method of doing business. The Department of Consumer Affairs license search is updated in real time as a license is renewed or anytime the status is changed. An easy access license search button is available on the homepage of the OMBC website. Consumers, employers, or any interested party can verify the license status online 24 hours a day, 7 days a week. License statuses can change at any time during a 2-year licensing period. The status can change from active to inactive, inactive to active, and licensees can be disciplined, which could have an immediate effect on their license status. If OMBC staff updates the status of a license in the BREEZE system, it is reflected immediately online, and the pocket license becomes invalid. For those reasons, the online license verification system has become the optimal license verification source for consumer protection. It's environmentally friendly. BRN, PTBC, which is the Physical Therapy Board of California, and Physicians Assistant Board no longer provide pocket licenses, citing the following reasons: facilitating access to accurate license information, operating with environmental awareness by eliminating paper, and significant cost savings in printing, paper, and postage. The elimination of the pocket license would abolish the board's need to purchase the printing and mailing services of pocket licenses through a third party. This would significantly reduce the use of plastic, paper, and postage required to create and deliver pocket licenses, which would lessen our impact on the environment as well. The cost savings, in addition to the environmental benefits and of eliminating the pocket cards, there are significant cost savings for the board as well. The cost of issuing pocket cards for fiscal year 22-23 was an estimated $22,175. The board would no longer need to contract with a third-party company, which I believe is KP, correct, to create and mail the pocket licenses, which will result in the board saving these costs each year. In conclusion, pocket licenses may not reflect a licensee's current status, as it may change within the 2-year license period, and they do not display enforcement action taken against the license, if any. The online license verification system is a real-time and accurate depiction of a licensee's physician and surgeon license status. Moreover, eliminating the printing and delivery of pocket licenses will benefit the environment as we find more ways to reduce our environmental footprint. Finally, the board will benefit by cutting costs associated with the issuance of a pocket license. I've also attached samples of what is currently being sent. Most of our physicians that are on the board know what they look like. And each license that is printed on a full sheet of paper, even though it's a fraction of, probably a third of the sheet of paper that's being sent out. And this is what our online verification portal would look like, or looks like now, with the accurate reporting. And I will say that for the licensing staff, a lot of the times, if we don't have a license verification in office to issue a license, we're going straight to the other board site. And as long as it's saying that it's primary source verified, which most of them are, as a result of COVID, that's what's being utilized.
Thank you. Any comments from board members?
So how do the doctors on the board feel about that?
I have yet to pull this license out of my wallet.
It's true. And with every license that is issued, that, again, time. So the staff is manually sending out an electronic submission of a wallet ID card, because a lot of the physicians don't need the paper. They want the electronic copy now, and most entities accept the electronic version. So
I
Great
agree.
idea.
I don't see the need for a paper license, honestly.
No,
saying,
medical staff offices actually prefer to have a PDF or an electronic copy when you're submitting and renewing your privileges. And I think everything Machiko put there is correct. There's, I think, no use for that cost. Plus, today we've heard so much about consumer protection. It's not up to date. It would be good, even if it, that it forces somebody to go onto the website and see here administrative disciplinary actions.
To point out, if you look at the sample that Machiko has here, the primary status is listed. In this particular sample, there's no secondary status. when there is enforcement-related issues, you would see a secondary status. So right underneath that primary status, I just want to point out that that's where you would see if they're on probation or probation completed. Right beneath that, public record actions, that's where you see the uploaded accusation and disciplinary order. So this is way more informative than your typical, pocket license. I do want to point out that through this process, we are late in the game. Like Machiko said, a lot of our healing our boards have already eliminated. Some of them have actually implemented a transaction where a licensee who wishes to have one can self-generate one. So that's the goal. If you are to move forward with adopting this decision, we could look into that and have that in connection with our Breeze account so that if you would like a copy, you can self-generate it at any point in time. Some boards have included a small fee of $25, which will be then payable to the Osteo board to generate some funds through that means. But that is something that we can definitely implement and look towards if you would like this to do that.
I think you should look into that. I know that some physicians may want a paper copy, so that would be good. But I would probably, like you said, charge a small fee.
All right, so we will at this point entertain a motion to eliminate the pocket license with the possibility of having a downloadable one on a case-by-case basis with a charge.
That's correct. And Michael just pointed out that it would require a regulatory packet to implement a fee. So keeping that in mind with all of our other rec packets we have.
Motion made.
I'll
So
second it.
let's separate that second part of it. Let's just make a motion to eliminate the pocket license.
Motion to eliminate the pocket license. And do we want to proceed with potentially still allowing the printing?
A future evaluation.
I think we would have to agendize that. And then Michael, can you confirm?
What we could do, I think what I'd recommend is for the motion to eliminate the pocket license and direct staff to investigate self-printing or other methods.
Perfect.
Okay.
All right, that's the motion on the table.
Motion as per Michael's recommendation.
Do we have a second?
I'll second.
Okay, so it's been moved and seconded. Is there any discussion from any of the board members? Any discussion from or comments from members of the public who are present? Moderator, any comment from members of the public who are online with us?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on agenda item 15, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We will give you a moment. All right, this is a moderator. I see no request for comment. I return the floor back to you, Mr. Board President.
Thank you. Seeing no comment, we will go ahead and take a roll call vote.
For Damian,
Aye.
Dr. Buhari,
Aye.
Dr. Jensen, Dr. Luzak,
Aye.
Andrew Marino,
Yes.
Dr. Patel,
Aye.
Denise Pines.
Aye.
Motion carried.
All right, so the motion is carried. Thank you. And we will eliminate the pocket license. Let's move to agenda item number 16, which is the election of officers. Madam Executive Director, Erica Calderon.
Thank you, Dr. Bahari. So we have a couple of board members that are terming out, so we do have to select new officers here. We will be electing a board president, a board vice president, and a board secretary for the 2024-2025 calendar year. The way that we will proceed will be the following. We will ask for nominations. We will ask for there to be a second. Ask the nominee if they would like to present any remarks, and then proceed with board discussion and public comments. For board president, do we have any nominations for board president?
I would like to nominate Denise Pines for board president. She's been a voice that I have looked forward to hearing at all the meetings and when discussing things where I could use her expertise. She's been board president on the Med Board and I think has a lot of experience and would be an excellent choice.
Is there a second?
I'll second.
Ms. Pines, do you accept the nomination?
I accept the nomination and would be honored to serve on this board as president.
Are there any other nominations for board president? Seeing none, is there any board discussion? Any comments from members of the public in the room? Any comments from members of the public online? Moderator?
Thank you, Madam Executive Officer. I've opened up the Q&A panel. If any member of the public would like to comment, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We'll give you a moment. All right, I see no requests for comment. I return the floor back to you, Madam Executive Officer.
Thank you. Machiko, can we please have roll?
Yes, ma'am. Corey Damian,
Yes.
Dr. Buhari,
Yes.
Dr. Jensen, Dr. Luzak,
Yes.
Andrew Marino, Dr. Patel,
Yes.
Denise Pines.
Yes.
Motion carried.
Congratulations, Madam Board President Pines. Are there any remarks you would like to say? Those are in order.
I would. First, I'd like to thank Dr. Bahari for his 2 terms, his 3 years as president. He's really been an amazing leader, not just here in California, but representing this board on a national level. I've really been inspired by him and have really enjoyed, communicating with him on the times that we've had to talk. And I know many of you have enjoyed his leadership as well. And to my, fellow board members, I hope to sort of, take his leadership and, take what we've been doing now that we have this really amazing executive director, this board to the next level and really create a national identity for DOs that, transcends what people have as an understanding. I have like a lot of expertise in PR and marketing, and so I have some ideas around how we can do that so that, people really understand who we are. Not that we want to get more complaints, but at least that people understand who we are. So I'm very excited. I'm excited to work with the staff as well. And I just sort of look forward to this next fiscal year. So thank you all for believing in me. I appreciate that.
For Vice President, do we have any nominations for Vice President?
I would like to nominate Andrew Marino.
Is there a second?
I would like to second that.
Mr. Andrew Moreno, do you accept the nomination? Are there any other nominations for Vice President? Seeing none, is there any board discussion? Any comments from members of the public in the room? Any comments from members of the public online, moderator?
Thank you, Madam Executive Officer. I've opened up the Q&A panel. If any member of the public would like to comment, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We will give you a moment. All right, I see no requests for comment. I return the floor back to you, Madam Executive Officer.
Thank you. Machiko, can we please have roll?
Corey Damian,
Yes.
Dr. Buhari,
Yes.
Dr. Jensen, Dr. Luzak,
Yes.
Andrew Marino,
Yes.
Dr. Patel,
Yes.
Denise Pines.
Yes.
Motion carried.
Congratulations, Vice President Moreno. Would you like to make any remarks?
I'd just like to echo my gratitude to my fellow board members. It's been an honor and distinction to be on this board. I've served on this board since 2017, so I'm very appreciative to have this honor. Thank you to the words of our new board president. I look forward to working with you, being of any assistance that I can be, learning from your leadership and experience, and I hope to serve my board members and the public well. So thank you again for this vote. I appreciate it very much.
Thank you. Moving on, are there any nominations for the position of board secretary?
I would like to nominate Gora Damian.
Is there a second?
I'll second.
Mr. Gore Damian, do you accept the nomination?
Yes, I do.
Are there any other nominations for the position of board secretary? Seeing none, is there any board discussion? Any comments from members of the public in the room? Any comments from members of the public online?
Thank you, Madam Executive Officer. I've opened up the Q&A panel. If any member of the public would like to comment, please either raise your hand or type comment using the field in the lower right-hand corner of the screen. We'll give you a moment. All right, I see no requests for comment. I return the floor back to you, Madam Executive Officer.
Machiko, can we please have roll?
Corey Damian,
Yes.
Dr. Buhari,
Yes.
Dr. Jensen, she's frozen. We'll come back to her. Oh, okay, there you are.
Like,
Yes.
Dr. Luzak,
Yes.
Andrew Marino,
Yes.
Dr. Patel,
Yes.
Denise Pines.
Yes.
Motion carried.
Congratulations, Board Secretary Gore Damian.
Thank you.
Please feel free to share any remarks you would like.
I will do my best to serve the board and the community. Thank you. I appreciate the nomination, and I appreciate it. Thank you.
Congratulations.
Thank you.
Congratulations to all of our officers. I look very forward to working with each and every single one of you this upcoming year. Thank you very much for your service in advance.
Wonderful. Let's move. Before we go to closed session, we have item number 17 on the agenda, which is the future agenda items and meeting dates. So far, we have our next meeting, May 2024, scheduled for Toro. And that's going to have the presentation on the aging brain. And then there are two dates on your agenda, I think, proposed for meeting dates, and those are August 15th and November 21st. I don't know if those made it to the agenda. They didn't, but those are two proposed dates. And I don't have a say in it.
Just for clarification, is it May 14th or May 16th? I think I've seen two different dates.
May 14. Oh, I am so sorry. It is the 16th, our usual Thursday. Thank you.
I thought so.
And keep in mind, you don't have to pick now. It's just the more you pick, the less you have to deal with at the next meeting.
That
And the longer you have to plan.
Right, right. It allows me to procure moderators, sites, things like that beforehand.
Already had that date scheduled though.
The May date, yes, that's been scheduled since I believe it was August of last year, the last meeting we had. So it's probably best to just schedule out through 2025 if possible. No, that sounds crazy since it's 2024.
I'm okay with August 15th, or are we deciding August and?
What were the dates? August 15th and?
Yeah, August 15th and November 21st, I believe, before Thanksgiving.
I'm okay with those dates.
That's fine with me.
Any particular location?
What's
That
been the
was-
pattern, Machiko, if you can share that?
So January is here in Sacramento. Spring, this will be our first time going back to Turo in some time. And then we try and visit Southern California as well. So Western or maybe Clovis. Try and now, since outreach is a little limited, but we want to reach more of the students, trying to make our way to all of the universities. Obviously, one would be left out at some time frame throughout the year, but yeah.
I think it's a good way to try to hit two birds, one stone.
Right. So we can entertain if we can go to Clovis in August.
And I believe we were at Western last time, right?
at Western
So
last
would
time,
you
so
like to
Clovis.
try the new university, Clovis?
Yeah.
Yep.
I will reach out to them. And then November, we can either play it by ear or we can try and pinpoint a location.
Probably come back to Sacramento.
Sacramento,
Yeah.
we could do that.
Mhm.
Sorry, what was the date for August again?
15th.
15th, okay.
Like Dr. Bahari said, we do have the presentation on the aging brain that's been scheduled for May. Any other presentations? I think we covered the diversion program today as well. I think we're good.
What was the date for the November?
November 21st, I believe. Yeah.
All right, so August 15th and November 21st look like the two dates for the next next meetings after the May meeting.
Do we want to do a January?
Not right now.
Okay.
Yeah.
Just to,
Yeah.
All right, so any comments, other comments from board members regarding those dates? Any comments from members of the public who are present? Moderator, any comments on those proposed dates from members of the public online?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please raise your hand or type comment using the field in the lower right-hand corner of your screen. And I do see that Michelle Montserrat Ramos has her hand raised. So Michelle, you should be able to unmute.
Good afternoon. My name is Michelle Montserrat Ramos, and I'm with Consumer Watchdog. And I have to put in another attempt to get your attention and request for a future agenda item that we discuss the complaint prioritization process for the board. Second recommended agenda item is a review of the uniform standards, how they are used and how effective they have been. Thank you.
All right, this is the moderator. I see no further requests for comments. So Mr. Board President, I return the floor back to you.
Thank you. Okay, so those will be the dates for you guys. Okay, we will adjourn the open part of the meeting and move to closed session.